strategic health authorities, from what I can gather, appear to have had a different approach. And in the southwest, I think there was a very clear policy approach to deal with the separation of provision of services by going down the route of social enterprise. Other strategic health authorities in other parts of the country have taken a different line, and if you look on the NHS website, you will see that there are a number of places where community services have been retained within the NHS, within existing trusts or within new community services trusts. If you look again on the DOH website, you will see that a social enterprise is described as a business. Interestingly, the DOH website gives the example of social enterprises such as the Eden Project and Jamie Oliver's 15 restaurant. That's the model that we're following. Again, probably all of you will be aware that in Stroud, a lot of these decisions were made, some of the time in confidential meetings, and so we were in a situation where the proposal was to transfer all of the community services provision in Gloucestershire, not just in Stroud, in Gloucestershire, into a community interest company by the 1st of October 2011. I mean, a couple of weeks ago it should have happened. Against the Cuts instructed Lee Day, which is a firm of solicitors in London who specialise in some of these public sector actions, to consider whether or not what was happening was lawful. The argument that is being run is that the decision of the Strategic Health Authority and the PCT is unlawful because they've essentially decided to pass £100 million worth of contracts, to novate them, which is a legal term, to pass them over to a company, a community interest company, which is going to run it, and that they have done that without considering any other option and without complying with the public procurement regulations, which next step is for Gloucestershire Health, the PCT, to be given an opportunity to lodge what's called an acknowledgement of service, setting out why or if they think they've got an argument in defence. That case, that acknowledgement of service has got to be back with the court by the 19th of November. There'll be then further opportunity for Stroud against the Cuts, and in this case Michael, who's the person who's got legal aid to run this case, to lodge further submissions, and then there will be a hearing in front of the judge as to whether or not the decisions of the PCT are lawful. What the court can do, if we are successful in our case, is to ask the PCT to reconsider the decision that they have made. We would be asking the PCT to do is to reconsider how they are going to run community services on the basis that it should remain within the family of the NHS. They are perfectly able to consider allocating community services either into an existing trust within the NHS or to set up an alternative community services trust, which is, as I have said, what many other PCTs across the country have already done. And there is no bar on them doing that. Certainly, if they were minded to, there is no necessity for them to contemplate a tendering exercise into the private sector at this stage, because they would have options within the existing NHS family. And going back to what Wendy said, it's the political will of the decision makers as to whether or not they want these services to remain within the NHS structure or whether or not they want to outsource them to a separate legal entity. And in fact, I would argue it's probably more complicated to outsource them to a separate legal entity than to retain them within the NHS.
I want to thank Wendy Savage for coming here.